Okay, so hello everybody. This is a talk by Freddie Lyons and myself, Andrew Peebles, on jurisdiction enforcement after Brexit. I'm not going to say very much by way of introduction. I'm going to go first and talk about jurisdiction matters. And Freddie's going to go second and talk about enforcement matters. We'll both say it at various stages. There's no possibility of us covering the entirety of this topic. It's quite a wide topic and it's also pretty dry, but we're going to try and hit on some of the main points. As we go through, there is a question and answer tab, which you can type questions into. Neither Freddie nor I will be looking at them as we speak. For obvious reasons, but we'll pull them up at the end. And if there are any questions and answers which are at least relatively straightforward, we'll give it a go. Anything a little bit more complicated, feel free to send an email either to Freddie or I, or both of us. And again, we'll do our best. If it turns out that it's the sort of thing that can only be answered by instructions, no doubt we'll feel free to tell you exactly that. But otherwise, and with that very short preamble, I think we should probably just get on with the talk. So, jurisdiction issues after Brexit. I'm going to essentially limit myself to three sets of regulations and or conventions, these being the current prime contenders. At the moment, jurisdiction within all of the European states is dealt with under the Brussels Recast regulations. Those, as you know, are very comprehensive, and they have within them a hierarchy system for allocating jurisdiction between the member states. And putting it very, very broadly, I'm sure you're familiar with them. The current hierarchy is domicile, and then special jurisdiction for contracts and torts in the place where a harmful event occurred. And then there are separate provisions for consumer rights, which allow consumers to sue essentially in the place of their choice. There are some separate provisions for insurance, which I'm not going to go into at all. And then there's exclusive jurisdiction clauses, which unsurprisingly have the result that where there is an exclusive jurisdiction clause, which is an effective one, then there will be jurisdiction for the member state nominated in that clause. We're all familiar with those, and they, to one extent or another, and they work very well for the simple reason that they provide a fairly clear set of, but very comprehensive set of rules dealing with all of the likely jurisdiction issues which may arise. Then the second set of provisions, which I'm going to deal with, is the Lugano Convention 2007. The writers in the course of the Brexit negotiations and earlier this year were proceeding on the basis that this was likely to be the convention which was acceded to and which would result in jurisdiction being dealt with between the UK and the member states. For reasons that I'm going to come to a little bit later, that no longer looks quite as likely as it did before. In the event, therefore, that we cease to be a member and the Brussels Recast regulations cease to have any effect, the fallback convention is the Hague Convention on Choice of Law Agreements, which is a very, very much more confined convention and will only apply to a narrow range of jurisdiction issues. The current position is that, as it sets out there under Article 67 of the Withdrawal Agreement, in respect of proceedings instituted before the end of the transition period, the EU rules on international jurisdiction continue to apply in the UK and member states in situations involving the United Kingdom. Essentially, therefore, the Brussels Recast will continue to have effect for all proceedings issued in the UK before the 31st of December this year, which is now not very long away. After that, the Brussels Recast Convention will fall away. It's a multilateral convention, and we can't decide for ourselves that we're going to continue to apply it, because that will have no effect on the other member states at all. And the result of that is that there is likely to be a period of abeyance when there are no effective conventions in force, or at least not fully in force. The reason for that is the Lugano Convention and the Hague Convention were entered into the EU on behalf of all the existing member states, including the UK. And so the UK's membership is only as a part of the EU. And that, broadly speaking, is the effect of the Treaty for the Functioning of the European Union and Article 216, which allows the European Union to enter into third-party conventions on behalf of the entirety of the Union. It's notable that in the latest EU notice to stakeholders in relation to this area, that version being published on the 27th of August 2020, accession to the Lugano Convention is not mentioned at all. And the reason for that appears to be that although on the 8th of April, the UK stated its desire to join, so far the European Commission are not playing along with that. There's plainly a degree of unsatisfactory politicking going on. Insofar as one can read between the lines at all, it appears that there's some idea that the creation of uncertainty will be bad for the English legal market, and therefore may redound to allow some European member states who wants to have a better share of the legal market to try to do exactly that. Whether it'll work or not, who knows? But the result of that is going to be distinctly less certain. In any event, accession to the Lugano Convention occurs on the first day of the third month after the deposit of the instrument of accession. And that's the final of 4 steps in the process of accession. And it requires agreement of all signatories before the convention is permitted to take to be acceded to by the UK. And the effect of that is that it won't happen, at least before the 31st of December 2020. Only after that 3-month period has passed can a convention even theoretically apply. And at that point, it will apply but to proceedings instituted after the accession. So at the least, there will be a gap in relation to proceedings which occur after the 31st of December this year and before effective accession. The accession to the Hague Convention is similarly spelt out as being effective on the first day following the expiration of 3 months from the deposit of the second instrument of accession. In fact, since I last gave this talk, I've done a little bit more digging around, and it appears that the UK entered a declaration on the 28th of September, in which it referred to having deposited an instrument of accession, which was to take effect immediately after the transition period is over on the 1st of January of next year. But there's a difficulty in that, and the difficulty is that there doesn't seem to be an agreement between Europe and the UK as to what the effect of that will be. The declaration contained within it a declaration that because the UK had been a member from 2015, which is when the 2005 convention came into being, that there would be a continuity. So the UK would simply continue to be a member as it always had been since 2015. But the difficulty with that is the one that I've already referred to. The European view is that the UK wasn't a member of its own right, but only as a part of the European Union. And Article 16 of the Convention is the transition clause, and it says that for exclusive jurisdiction clauses, it will only apply to contracts concluded after entry into the Convention. And the view, therefore, is that it won't apply to contracts concluded between 2015 and the end of 2020. I don't know how that row is going to work itself out. As Freddie will say, there's a Vienna Convention on treaties, which allows for the determination of disputes over the effect of treaties. But personally, I logically can't see an answer to the European point of view, but I can't pretend that I've done an inordinate amount of research on the topic. But it does seem to me that Article 216 of the TFEU and Article 16 of the Hague Convention provide some difficulty for the English approach. And the result will be that there will be a gap for litigation commenced, but which relates to jurisdiction clauses that were entered into before the end of 2020. Right. The Lugano Convention, what is it? There were a series of attempts to deal with jurisdiction in Europe, starting with the Brussels Convention of 1968 and then the first Lugano Convention of 1988. The Brussels Convention was renegotiated in 2001 and became a set of regulations rather than a convention. And the idea of the 2007 Lugano Convention is that for those residual cases where it applied and the regulations did not apply, the two would be brought into the same form. So it was intended that the Lugano Convention simply mirror the Brussels regulations, and they would have exactly the same effect as one another. But since then, the Brussels Recast Convention and the 2012 regulations has come into play. And the effect of that is that there were changes between the original Brussels regulations from 2001 and the Brussels Recast ones. And those changes were obviously not mirrored in the Lugano Convention. So there is a disparity between the Convention and Brussels Recast. And in particular, there was an amendment in the Brussels Recast to the treatment of exclusive jurisdiction agreements, and I'm going to go on to deal with that in a greater detail in a moment. Secondly, there's a difference in the wording as to the treatment of decisions of other courts in the European Court of Justice between the two. Under Protocol 2 of the Lugano Convention, the court must pay due account to decisions by another contracting state court or the ECJ. In Europe, you are bound by the ECJ and there's res judicata for decisions by other state courts. That has been the excuse latched onto by the EC in not wanting to sign up to the Lugano Convention for fear that it will create a non-level playing field. I have to say, I don't really think that's very convincing, but no doubt it'll do for the politicians. There are also slightly amended provisions relating to choice of jurisdiction for consumers. There was a broadening of the domicile clause, which meant that it had a wider application in theory. I'm not convinced that that's going to be of enormous importance, so I've mentioned it, but I'm not going to go on and discuss it in any greater detail than that. With that degree of preamble, I'm going to take you on to the case of Mastermelt. And the reason I'm going to take you on to that is because it's a useful demonstration of the difference that we've mentioned between the Lugano Conventions and the Brussels Recast Convention in relation to exclusive jurisdiction clauses and the way in which lis pendens works. So what happened in Mastermelt was Siegfried in Vienna's a Swiss company produced catalysts. The catalysts became exhausted and they wanted a pure metal to be extracted by Mastermelt in the UK. Mastermelt did that and there was an issue over quality. So there was a straightforward claim. I don't know how straightforward it was, but there was an easily recognizable claim by Siegfried, the Swiss company, for fitness for purpose. So it's an ordinary contractual claim. They threatened to bring proceedings in Switzerland and stung by that, preemptive proceedings seeking declaratory relief were issued in England first. In response to those proceedings, Siegfried and Vienna's issued proceedings in Switzerland, and the Swiss court, so both courts were seized, and the Swiss court, an application was made by Mastermelt for a stay, which was refused by the Swiss court. That then disappeared up into the appellate jurisdiction, and before an answer came back, the application, the reciprocal application to stay or dismiss English proceedings was heard in England and in the High Court. Next one, please. In the course of that application, it was common ground that under the Lugano Convention, the place of performance of the contract was the UK. So the jurisdiction would be in the UK, unless there was a relevant exclusive jurisdiction clause in favour of the Swiss courts, in which case jurisdiction should be vested in Switzerland. In the event that was determined in favour of the Swiss court, but only by the English court going through the process of making findings as to the validity of an existence of an exclusive jurisdiction clause in favour of Switzerland. So it went through the contract and came to a pretty clear conclusion. All that was needed was a good arguable case. It's apparent from the decision that the judge thought that it was much better than a good arguable case, but that wasn't necessary for him to go into. So that was the actual result, and then it went back to Switzerland again. In the course of that, argument, the court needed to determine whether the Lugano Convention should be read as though it still exactly mirrored the Brussels Recast Convention. So the preamble to that is, under Article 23 of the Lugano Convention, where a party is domiciled in a convention state and there is a relevant exclusive jurisdiction clause, the state nominated in the clause will have jurisdiction. But by Article 27, the court first seized will also have jurisdiction. And the effect of that is that if somebody started preemptive proceedings in a different court from that nominated in the jurisdiction clause, the court first seized had to make findings as to the contract and the existence of the jurisdiction clause in order to cede jurisdiction. Unless, next slide please, unless Article 31.2 of the Brussels Recast was imposed. Article 31.2 of the Brussels Recast was an addition to deal with what was then perceived as a problem. And that required the court first seized to decline jurisdiction if there was an exclusive jurisdiction clause in favour of another member state. And that reads, where a court of a member state on which an agreement, as referred to in Article 25, confers exclusive jurisdiction is seized, any court of another member state shall stay the proceedings until such time as the court seized on the basis of the agreement declares that it has no jurisdiction under the agreement. And the reason for that change was to get rid of what is known as the Italian torpedo problem. And the Italian torpedo problem was neatly summarized by Mr. Justice Waxman in the course of the decision. And he says, and again, I'm going to quote it because his words are nice and concise and very clear. Part of the underlying problem, which Article 32.1 of the recast regulation sought to solve, was the fact that by reason of Article 27, there was the potential for abuse, because, provided the proceedings were timorously started first in the court which was not the subject of any putative exclusive jurisdiction clause, the party relying on the exclusive jurisdiction clause would have to wait, sometimes for an extended period, until the court first seized concluded that indeed it had no jurisdiction. I pause to say that's exactly what was being attempted here in the English courts. This ability to delay claims from proceedings in the correct court became known as the Italian torpedo. The decision of the European Court in Gassa entrenched the position because it held Article 17 of the Brussels Convention in materially the same form as Article 27, which is the one I've just referred to, applied so as to give priority to the court first seized. This was so even where there was an exclusive jurisdiction clause purportedly in favour of the court second seized. In other words, Article 27 was of general application and there was no carve out for exclusive jurisdiction clause disputes. Now, one can easily see why the argument was raised that there had to be a reading up so that Article 31.2 of Brussels Recast was essentially inserted into the Lugano Convention with the effect that the Brussels torpedo problem didn't work and the English court would have automatically to cede jurisdiction to the Swiss courts to work out whether or not there was an exclusive jurisdiction clause. The English court declined to stay on that basis. They said that Article 31.2 did not apply reflexively to the Lugano Convention. And it couldn't be applied by analogy, so that it had to go through the process of determining whether there was or not an exclusive jurisdiction clause as the court first seized. I pause there to say, broadly speaking, amendments put in the recast seem to me to have two different functions. One's a clarification function. So there were decisions which arose, which interpreted the existing Brussels regulations. And those amendments dealing with those decisions were clarifications, not changes. This is an example of the other type. This is a change, and it was a change because the existing regulations were conclusively determined to have an effect which gave rise to a problem. And so a change was inserted into the Brussels recast in the form of Article 31 in order to change the meaning of the regulations and get rid of the problem. So I, for what it's worth, because I'm not sure Mr. Justice Maxwell needs my endorsement, it seems to me entirely logical that he concluded that you couldn't simply decide that that change was reflexively applied. The Lugano Convention in its existing form did not permit of that interpretation. The result is, as it currently appears, the Italian torpedo issue remains. And it remains as a weapon to potentially to derail timely resolution of claims where there is an exclusive jurisdiction clause if the Lugano Convention applies. But the Brussels recast obviously will not. The problem is actually quite neatly exemplified by these proceedings. There were two simultaneous sets of proceedings, which is obviously both expensive and time-consuming and difficult for all of the parties. And of course, there's a home court advantage. So there's the general feeling that if you manage to start proceedings in your home court, you're more likely to get a favourable result as to whether or not there's a binding EJC. But also in some of the less efficient courts, and perhaps it's not a mistake, but it's called the Italian torpedo, the court first seized will take a long time to determine that it shouldn't be seized. And the effect is you can put down the line for a considerable period of time any prospect of getting a resolution on your claim. I have noted there that this can't be regarded as settled because the Swiss court, when it refused its stay, determined that the Brussels Recast Convention should be applied reflexively to the Lugano Convention, and that therefore that's why they remained seized in spite of the fact that they were the second court. And this is a neat example also, therefore, of the difference between the Brussels Recast and the Lugano Convention, where you've got the Protocol 2. So under Protocol 2 of the Lugano Convention, the English court only needed to have regard, sorry, that type should have been changed, to the Swiss decision, and the Swiss decision was not binding. And indeed, the English court concluded it was wrong. So that is a summary of one of the principal differences between Brussels Recast and Lugano, which writers on the topic have harped on about as an important difference, which is makes the Lugano Convention a less desirable one. I'm not sure how many travel claims that's likely to apply to, but nevertheless, it's something to be aware of. In any event, as we've noted, currently there doesn't seem to be very much prospect of the Lugano Convention being the relevant convention, which is a shame, because otherwise it very much would have mapped out similar grounds to the existing Brussels regulations and being very much more of a coverall than the fallback provision, which is the Hague Convention. I note, incidentally, and Freddie will refer to it in more detail, that there's a 2019 convention on jurisdiction enforcement, which is very, very much wider than the 2005 convention. Since Freddie is going to talk about it a little bit, I don't need to say very much more than that this is an extremely fledgling convention. And because it's such a fledgling convention, in other words, it's not at the moment one which I think is necessary to look at in any detail, but it is obviously one to keep an eye on. Under the 2005 convention, there is allocation of jurisdiction to signatories with an exclusive jurisdiction clause. And by Article 6, the non-designated court must stay or dismiss proceedings subject to the exceptions listed in Article 6. Again, I don't need to go through those. They're relatively confined, although, as is the way with most jurisdictional things, there's been quite a lot of argument about whether they apply in individual cases. But these rules don't apply to exclusive jurisdiction clauses where the matter is a claim for personal injury or consumer claims, i.e. claims under an individual acting primarily for personal, family or household purposes. So those claims are likely to encompass a large number of claims within travel. I know a couple of things. First of all, both the Brussels regulations and perhaps more pertinently for the purposes of this talk, the Lugano Convention had a similar carve-out, not the same carve-out, but a similar carve-out for consumer claims, because the circumstances in which exclusive jurisdiction clauses were allowed to oust the very wide choice of jurisdiction in consumer claims was also very much limited. So Article 17 of the Lugano Convention is what applies to that. But the effect is that ultimately the scope of this convention is not going to cover a very large number of disputes which you're concerned with within travel. Thank you.
Right. I've got the fun topic of enforcement. Let me just check to see if it's coming through. So I have the topic of enforcement. This is historically been seen by council as something of a dark art done by solicitors largely, even in cases of foreign enforcement, but especially in cases of enforcement within the EU member states, because at the moment things are done quite simply. On exit day, as Andrew has already alluded to, on the 31st of December, the UK will cease to be a signatory to the Brussels Recast and Lugano. And that is because of the way in which those treaties were entered into. And that's going to affect the enforcement of judgments for the signatories of those treaties, primarily the entire EU, all the EU 26 members plus Denmark, Denmark often being an exception in these issues, but not in this case, Iceland, Norway and Switzerland. It is something which I anticipate, for reasons that you'll see throughout this talk, is likely to be something where council and indeed solicitors will be involved more in future, and there may well be more contested applications of this type. Certainly, I've had fairly recent experience from a case which I finished involving a coach crash in France, where having settled it, we were greeted by the one of the insurers saying, well, we're a French insurer, good luck enforcing it. Fortunately, we were able to point to Article 67 of the withdrawal agreement and say, well, actually, we're going to be all right. But that is not going to be the case, obviously, for those claims brought after the 31st of December. So this talk can be divided into the following sections. Firstly, how does the enforcement process work now for these states? What might happen post-Brexit? And for the reasons that Andrew said, and obviously I know that negotiations are now ongoing, we're still in a very, very uncertain position with regard to that. And finally, what will those potential options mean for you as a cross-jurisdictional litigator? So I'll start with how enforcement works now with the easiest of the enforcement options, which is an EEO, European Enforcement Orders. So this applies to all member states except Denmark, so to the EU 26, if I'll describe it like that. It applies in a fairly limited range of circumstances, but it is still going to be fairly commonly relied upon. So in all uncontested claims, including essentially any claim that's settled by settlement without a court adherence and default judgments, you can apply for an EEO. The process is really simple. It's all there in CPR 7428. You fill out the N219 or the N219A. You attach the relevant specified documents, which is essentially the judgment and a couple of other bits, but not much. And the court will simply rubber stamp the recognition of the foreign judgment, and you can proceed directly to enforcement. There is no procedure of certainly what used to be known, but is still sometimes known as exequatur. So there is no further procedure. It's a one-step process that you can go straight to enforcement. We can pretty well safely say that this process is almost certain to disappear following Brexit. I think it's fairly unlikely that we will be renegotiating a very similar deal to this, partly because no one has suggested that we will yet, and partly because the EU has no other deal that replicates this with any other country or group of states. So I think it's very unlikely that we're going to see more of this in the future, which is a shame because, as I say, it's very straightforward and it's very cheap. In fact, often free to go through this process. So if your EEO doesn't apply, then you're under Brussels Recast. That is all member states, including Denmark, and it's been incorporated into Danish law by Danish law number 518 of the 18th of May 2013. In England and Wales, it applies to all judgments, barring one or two exceptions, made after the 10th of January 2015. It is, as a result, exceptionally unlikely that you are going to be seeing anything where people are trying to enforce a judgment made prior to that date. Now, we are dealing almost exclusively with things that were under Brussels Recast rather than the previous Brussels regulations. Again, no application for exequatur required. That's pursuant to Practice Direction 74A, paragraph 7.1. The procedure is really, really straightforward. You need a sealed copy of the judgment, and you need a certificate of recognition. Now that is attached to the Brussels Recast Treaty in the terms that you need. It is very, very straightforward, and the court of origin where the judgment came from is required to complete the certificate for you. So if they don't, you can essentially go and insist, pointing to Article 53 of Brussels Recast. If the judgment were to be a non-money judgment, for example, in the kind of claims we might deal with, an injunction, then you need additionally to get the court of origin to confirm that it's got jurisdiction to make that and that the measure is enforceable in the state of origin. That again should be straightforward. They're required to do that. It's also part of the form, which rather than give two separate forms, they obviously thought it sensible to only do one. So again, it shouldn't be difficult to get, and the process is very cheap. It's I believe about £100 for that process. So very easy, and it's almost a single step process. If you're trying to enforce a judgment as between the UK, Iceland, Norway, or Switzerland, then you're into Lugano 2007 territory. Those ones, of course, Andrew's described the difficulty that we may have in acceding to Lugano, and I'll go into that in a little bit more detail. The process is slightly more complicated, but again, pretty straightforward. It's all set out in the CPR. You've got to make the application at the High Court. It's a specified court for each of those contracting states. It's all, again, within the convention. You've now got to do a two-step process. So you need to do recognition of the judgment first and then enforcement. You're required to give very similar information as you do under Brussels. As you can see, there's a form to be filled out by the origin court again. And in England and Wales, although slightly weirdly, not in the other countries necessarily, and certainly it's not required by Lugano, you need to provide a translation of the judgment and a statement dealing with the amount and rate of recoverable interest and confirming whether that's recoverable at the state of origin. As I say, it's a two-step process because you need to give an address for service, and once the judgment is recognised, then it needs to be separately served upon the person you're trying to enforce it against, and there needs to be time allowed for that service, and thereafter you can enforce it. So it's not an automatic provision to enforce, but it is only adding a relatively short amount of delay into the process. So that's where we are now. These are the various options that we might be facing down post-Brexit. Again, the negotiations are, if anything, at a more uncertain stage than they were before, in that 2 weeks ago, when I was considering this talk, I could have said, well, realistically, we're not going to be getting a deal. There's now looking like there might possibly be a deal. We're just going to have to wait and see. So the options are, one, bespoke agreement which recreates the Brussels Recast system. It has to be said that there doesn't seem to be any particular appetite for this on behalf of the EU member states. An entirely bespoke agreement, it may be felt, probably sends the wrong message in terms of whether or not a country is effectively being punished for leaving and whether or not they are in a beneficial situation. It could well come across as being seen by the UK to pick and choose those parts of being in the EU they like and those parts that they don't. So I think that this is probably not something we're going to see, but who knows, we'll wait and see within the next few weeks. Option two, accede to the Hague Convention 2005. Well, as Andrew says, we're going to do it. This is going to happen because the articles of accession have already been lodged. It applies to all EU countries, but not necessarily to their overseas territories. So if you are unfortunate enough to be trying to enforce a judgment from Greenland or the Faroe Islands in the UK, then I've got some bad news for you. Denmark has said no, that it doesn't apply there, and so you're going to have to go through an entirely different process, which we will come on to. It also applies to Montenegro, Mexico, and Singapore, so it's slightly broader in scope. However, that is only in one way of describing scope. It is very narrow as to what the type of work that it applies to and the type of cases it applies to. So it only applies where there's an exclusive jurisdiction clause. Consumer contracts, however, even with an exclusive jurisdiction clause, are excluded. It doesn't apply to any personal injury, even if the relationship is based on a contract. And it doesn't apply to contracts for the carriage of passengers and goods. Now, obviously, we know that there are other treaties, primarily Montreal, Athens, and Bern, which deal with the carriage of passengers and goods. So that is unlikely to be a particular issue, but the other ones are likely to be, and frankly, it doesn't look like Hague 2005 is going to be very helpful. So although we've heard quite a lot of fanfare about how easy it's going to be once we're a member of Hague 2005, and although we've gone to the effort of joining, realistically, for non-commercial concerns, it's just not going to apply. It's not going to make any difference. Where you might see this in a travel context is potentially between disputes between your suppliers and tour operators. if that is subject to an exclusive jurisdiction clause. But that is really, really it. Option 3 could accede to Lugano 2007. We've already talked about the process of enforcement under Lugano. It's obviously not as straightforward as under Brussels, but it's still relatively straightforward. The FTA members, not Liechtenstein because they're not a Lugano signatory, but the other FTA members, Norway, Iceland, Switzerland, have expressed willing to accept the UK's application to Lugano, but there's still no indication from the EU. There is a particular difficulty, well, there's two difficulties. From the UK's perspective, signing up to Lugano means they're subject to ECJ jurisdiction in terms of the interpretation of that treaty. From the EU's perspective, the UK is not a member of the FTA, and so they seem to be getting benefits of being part of the trade association without being a member. So again, it's not entirely obvious what will happen with this. As Andrew said, there is already going to be a delay. The deadline was the 1st of October to be in by the 1st of January, assuming everything else went smoothly. That has obviously been missed. So regardless, there is going to be a gap. We don't know yet whether that will be weeks, months, or indefinite, but we'll wait to see. Fourth option is to accede to the Hague Convention 2019. Now, this convention is great. It applies to tortious claims, it applies to consumer claims, it allows for a straightforward and cheap two-part enforcement procedure. It's very similar to Lugano in that respect. It's actually designed to be very similar to the enforcement of arbitration awards, again, which I'll come on to a little bit later. But, and as Andrew has alluded to, this is a major issue, and it is a major but. It's only been signed by the Ukraine and Uruguay at the moment. It won't be enforced in any capacity at all until April 2021, because the Ukraine only signed it this year, and Uruguay, it would be extraordinary if they did, but Uruguay can object to the Ukraine having signed it until April 2021. And as such, the treaty isn't in force as between two states, and therefore isn't in force until that date, even if more signatures are added, because of the dates that other countries could object. So even if the UK and the EU agree to be bound by its terms and sign up, that really realistically won't have any force until 2022. It would make a lot of sense if they would, but given that this convention was all agreed back in 2019, and given no one else has signed up to it, whether or not it will happen is still up in the air. It would solve a lot of the issues of Lugano, because it would solve the jurisdictional issue and also the FTA issue. But we'll see what happens with it. Well, I put option 4 twice there, but option 5, revert to the pre-existing bilateral and multilateral treaties. This is an interesting academic talk, I think, and it's an academic discussion, and it has been subject to a significant amount of academic dispute. Primarily, that is because the Brussels Treaty 1968, so the original Brussels Treaty, which was originally entered into by 6 states, not the UK, in 1968, but continued to be entered into by other states until we got to 15 in 2004, has not been replaced or repealed. That is unlike the earlier 1988 Lugano Treaty, which has been fully repealed and replaced by the later Lugano 2007 Treaty. That's not the case for Brussels. So there is an argument that this would still apply as between the 15 member states. It would not apply to the Eastern Bloc states, so there would still be a significant gap. One particular point on this about whether or not it would apply is whether or not the treaty is still in application as between the states. Obviously, directly between the member states, it's not. but is still used in cases involving Mayotte, the French overseas territories, and Aruba. So arguably, there is still an application to this treaty as between those who have signed it. We'll come on a little bit more to that, but it is a very complicated topic. If we revert to those treaties and to the Brussels 1968, then enforcement is under the Civil Jurisdiction and Judgments Act 1982. It doesn't require the matter to be issued as a separate claim, but is a more complex two-part procedure for recognition and subsequent enforcement. It does require exequatur to be gone through. So you need to establish that the treaty is the judgment is appropriate for recognition by the England Welsh court before it can go any further, and then there's the time built into it. It is still much cheaper than issuing a claim. I think again, £100 for the application for recognition as opposed to the full cost of issuing a claim. There are other bilateral treaties as opposed to a multilateral treaty. Those are enshrined in the Foreign Judgments Reciprocal Enforcement Act 1933. These have fallen into abeyance, but again, they haven't been replaced. They are applicable to Austria, Belgium, France, Germany, Italy, Norway, and the Netherlands. And again, there's a similar two-part enforcement procedure as under those Civil Jurisdiction and Judgments Act cases and under Brussels 1968. Again, it's complex, but it is more simple than issuing a claim. And the reason that's important, and this is where we cease to be entirely academic, the reason that's important is because if your claim needs to be issued and enforced under the Foreign Judgments Reciprocal Enforcement Act 1933, then it is a serious procedural faux pas to, in fact, seek to issue the claim as opposed to going through the mutual recognition procedure. Now, at the moment, that applies to Australia, except Norfolk Islands, Canada, except Quebec, Guernsey, Jersey, the Isle of Man, India, Pakistan, Tonga, Suriname. But if it also applied to Austria, Belgium, France, Germany, Italy, Norway, and the Netherlands, then you would be in a position of having to go through the Foreign Judgments Reciprocal Enforcement Act procedure rather than issuing on the claim. Now, the Foreign Judgments procedure is subject to, it's in fact a 6-year limitation, so pretty similar limitation, but that limitation is itself subject to the limitation in the origin court. And some of these places, particularly Austria, for example, which has a 30-day limitation period in some circumstances for enforcement of judgments, the enforcement of judgment limitation can be very short. And so if the claim was inappropriately issued and then thrown out, and we know that that's what would happen because of the case of Yukon Gold and Clark, the 1938 decision that I put there, then although theoretically it could be brought back and resurrected, it might well be out of time, or certainly that's possible. It would certainly be very expensive for the person seeking to enforce it, and the mistake could be costly. But the answer is, at the moment, we don't know if that Foreign Judgment Reciprocal Enforcement Act is going to apply, partly because we don't know what the deal is, and partly because we don't know actually whether those treaties will stand up to scrutiny. I've done these two maps to demonstrate what those processes look like. On the left, you've got the pre-Brexit enforcement regimes. So in orange, you've got the common, effectively the country's own common law rules apply. You've got in blue the Lugano 2007 countries, the EFTA countries, and in pink the Brussels Recast countries. The change in the landscape is pretty huge. If you turn then to the one on the right, post-enforcement regimes, in green, those are the countries which have a bilateral treaty with the UK, which hasn't yet been, it may have been superseded, but it hasn't been actually revoked. In pink are those additional countries to which Brussels 1968 applies. And then in orange, you'll see the expansion of those where common law rules apply. So these are the issues that we've been going through. Again, with the Norway agreement, there is an explicit superseding within Lugano 2007, but the word used is that it supersedes it. It doesn't revoke it, nor does it replace it. So in those circumstances, arguably that treaty with Norway still lives. But one needs to consider the Vienna Convention on the Law of Treaties 1969. Now, you may think, well, how can this possibly apply to Brussels 1968, given that the Vienna Convention has no retrospective effect? Well, the reason is because of the way that subsequently the UK and various other countries have entered into that treaty after the date of the Vienna Convention. Now, under the Vienna Convention, there are various provisions by which countries can agree to come out of their other treaty obligations, which effectively kill off those treaties. We simply don't know what will happen with that, and the jurisdiction is not going to be the English court. It's not even going to be the ECJ. The jurisdiction is going to be in the International Court of Justice in The Hague, because they deal with interpretation of the Vienna Convention. The academic discussion largely settles on whether you take a literal approach to the Vienna Convention or whether that approach is purposive. If it's purposive, these won't apply. If it's literal, they might still apply. But we're going to have to wait for the answer on that, and hopefully we won't need it. If none of them apply, then we come out to the position at common law. These are the positions as between the countries, those countries in orange as well, in any event, if no deal is reached. You're going to have to issue the claim issue a claim on the judgment. Now, for those of you who practice within cross-jurisdictional work, that won't be unusual. Certainly, it's what you do, for example, if you have a judgment from the US or a judgment from anywhere that we don't have a bilateral treaty with. But it's not something that we've been used to dealing with the EU member states. That claim is issued Part 7. So again, you've got the full cost of a Part 7 claim. And then afterwards, you've got to proceed separately to enforcement, assuming you get usually a default judgment. But if not a default judgment, then you've got to fully contest. Then you're going to have to proceed to enforcement in the usual way. It is going to be expensive with the court deadline backlog as well. It's going to be very time consuming. It is going to put a significant amount of delay in your enforcement of your litigation if you are seeking to enforce. If you are not seeking to enforce and you are seeking to, in fact, delay paying up on behalf of your client, who has instructed you to do so, then there are many more opportunities to do that under this method. That's because under our own rules, so for example, if you're seeking to enforce a foreign judgment here, the court needs to be presented with evidence that that judgment was final and conclusive for an ascertainable sum of money made by a court which had the jurisdiction, not obtained by fraud, although we don't consider the merits in any particular detail, not an affront to English and Welsh public policy. So that might be something like a punitive damages order or similar, which might be an affront to English and Welsh public policy, and not an affront to natural justice. Usually, as I've said there, that's where the defendant has had a proper opportunity to respond to the claim in the court of origin. Now, that's just one example. Now, each country will have their own rules. Now, in some places, it's quite straightforward. In Germany, for example, this is all dealt with by their own civil code. In Greece, for example, I'm told there is an opportunity somewhat to consider the merits. And that, again, will set things back. It will make things more tricky. So what can you do about it? Well, if you're acting for a claimant, issue. I've been saying it for about 2 years now, but it's very, very important to get these claims issued protectively if you can, to avoid this coming up. I would even go so far as to say that if you are in the process of complying with the pre-action protocol, it is the kind of situation where you could absolutely issue before finishing compliance with that and complete compliance afterwards. It is that important. For large claims, particularly, you might consider whether the matter is suitable for arbitration. That's because arbitration awards are easily enforced between contracting states, the New York Convention 1958, which all EU member states are in terms of being contracting states. That enforcement procedure, as I said in relation to the Hague Convention 2019, is again very straightforward. It's slightly extraordinary that we're in a position where those arbitral awards made cross-jurisdictionally would be so much easier to enforce, but that is where we are. As a defendant, or as somebody who's going to be potentially resisting these, you've got to start going back to that common law case law for these, because there is an increased scope to defend cross-jurisdictional enforcement actions on procedural grounds, such as, for example, the one that I raised earlier with the Foreign Judgments Reciprocal Enforcement Act. So there are opportunities here for effectively for further litigation. Whatever happens, I think it's fairly safe to say that it is going to be more time consuming, it's going to be more expensive, and it's going to be more open to question. But we'll wait and see, and hopefully we'll know in a few weeks. That's our talk. Now, we haven't had any questions yet, but we did have a question before the talk started, which related to Scotland. And the question we were asked is whether in a case where there was a Scottish defendant who was an individual who lived in Scotland, and also an accident that occurred in Scotland, but that the claim had been brought by an English company in England, and an acknowledgement of service had been filed contesting jurisdiction, what needed to be included in that kind of application? And I think I've interpreted this somewhat in answering. In terms of our talk and post-Brexit, there is relatively limited effect on the relationship between the home nations. There is some, which, and if you've been on Westlaw recently and looked at the Civil Justice Enforcement Act 1982, there are some pending changes to that legislation. It doesn't change my answer to this question, which is that under the 82 Act, it's very, very clear, both pre-Brexit and post-Brexit, that in a case like that, because it imports its own version of the Brussels Recast Treaty, but isn't in fact the Brussels Recast Treaty, that there simply wouldn't be a jurisdictional gateway for that sort of claim. So there wouldn't be any need to consider which was the more convenient forum for the claim between England and Scotland, because the English claimant, with a tortious action that occurs in a foreign jurisdiction against somebody domiciled in that foreign jurisdiction, simply doesn't have a jurisdictional gateway. And so an application contesting jurisdiction should address those issues, primarily dealing with the fact that under Schedule 4 of the Act, there is a very limited jurisdiction given to a court to consider any other factors. And the only other factors that they need to consider are, for example, where the tort or damage occurred. And in this case, it all occurs in Scotland. So there is no issue there. I wouldn't suggest that you go much further.
Good. No, I agree with that. And there are still no other questions. So I think that's us casting our small net on a sea of speculation. Thank you very much for listening along with us. Hope it's helped a little bit.